Well, hello and welcome to this Duty to Question podcast by EBSWA, the Evidence-Based Social Work Alliance. EBSWA was established over 6 years ago in 2019 to speak up for and call for an evidence-based approach to sex and gender identity in social work. Practice in social work has been based on ideology and a denial of the evidence. So EBSWA has provided a voice for question and for dissent by social workers. My name's Maggie Mellon. I'm an independent social worker in Scotland and a founding member of EBSWA. I am joined by our guest speaker, Sarah Phillimore, a barrister in the family courts in England, and also by Charlies Plummer, a fellow EBSWA founder and social worker in practice in England. Sarah's an active commentator on the legal issues raised by gender ideology, not just in relation to children and families, but also on the impact of the capture of the police and other agencies, organisations by the ideology. And she and her colleagues have had significant victories in defending free speech. However, this podcast will focus on the state of the law in relation to children, which have come before the family courts. So I'm going to invite Sarah to give us a short introduction and on the sort of the legal situation with children and the cases, the issues raised by the cases, and her thoughts about this. And then I'm going to invite Charles to talk about his experiences at CAFCASS and the situation there. CAFCASS is the agency that advises the courts on children, the social work agency that advises the courts on children. So, welcome, Sarah, and thank you very much for taking part in the podcast. And over to you.
Oh, thanks very much for inviting me. I think this is such an important area. So, what I'd like to do is just give a quick canter through the development of the family courts with regard to children and gender identity, and then perhaps just touch on the implications of the Supreme Court judgment in For Women Scotland. And then hopefully, Charles can expand upon what I'm going to say about the absolute vital necessity of social workers stepping up to the plate in these cases. Because if the social workers and the court fall, the child is left utterly unprotected in these cases. And as we'll see when I touch on this briefly, that's been really, really serious for some of them. So I'll start with Reed J in 2016. That's a really interesting case because it shows the court doing exactly what it should have done, but it's also a very, very worrying indicator into how social workers were captured by gender identity ideology. Because you had there a 4-year-old boy who was said by his mum to disdain his penis. And all the social workers went along with that. The little boy's dad was quite horrified, and this ended up in care proceedings. And the judge really couldn't have been any sterner. He said the local authority had been swept away in these sort of fashionable ideas about gender identity. There was no evidence at all that this little boy disdained his penis. And even if he did, the way forward was obviously not to consider setting him on a pathway to medical or surgical transition at a later age. And I was just reminding myself, having another look at what I've written about that judgment, the judge was so concerned, he called for a thorough review of the social work involvement in this case by the Director of Children's Services. And I don't know if that review ever happened. I certainly haven't seen it published, but that's a pretty rare thing for a judge to do. I've certainly never come across it before. So you can see how seriously the judge took it. And of course, who was supporting that mother in court but mermaids? And they apparently were chuntering on and said the judge didn't understand what he was doing and they were going to help the mother appeal. Well, that appeal never came. So there you had the court doing what it was supposed to do and protecting that little boy. What went horribly wrong, though, for the family courts, we can see by just fast forwarding 3 years to the case of TP. Now, that case involved two unrelated foster children, aged 7 and 4, who both apparently expressed a wish to socially transition. The only person worried about them, I can't work out from the case if the parents were even consulted and maybe they weren't on the scene, but the only person to express concern, and briefly, was the children's guardian. And she was immediately squashed. And I think Charles can talk at some length about the pressures that must have been operating on her. And what's quite chilling about that case is the judge was obviously patting himself on the back for being so forward thinking and so hip and with it that he was alert to these very exciting changing times and how a child as young as 4 could express a view that they wanted to be the opposite sex. So that case left a real chill for me because those children had nobody. Without the social work team, without the guardian, without the court, their parents weren't on the scene, they had nobody. And I think about them often and I wonder what did happen to them. And of course, as ever in family cases, we very rarely get any follow up. We just don't know. Then, of course, we had Kira Bell's very, very helpful efforts to get a judicial review on the actions of the Tavistock. Now, that did obviously cause enormous concern because that case was instrumental in the commissioning of the CAFCASS review, and we see what happened there. However, the first judgment of the Divisional Court was overturned by the Court of Appeal because it said the court had overstepped. The court had imposed some quite rigid requirements on when you could assume a child could consent and when they couldn't. And the Court of Appeal said, and I have to say quite rightly, that's not the function of a court. That is, in effect, a subversion of our democracy because the court's stepping into arenas where it may not have the proper information. It certainly hasn't been elected to do any of this. What it was trying to do was regulate the medical profession, and that was beyond the scope of its powers. So, although the decision in Bell was overturned, in a way, it was the most significant victory that we had because the shockwaves were seismic when people began to realise what was happening. I think the youngest patient at the Tavistock was 10 years old. And when the Tavistock actually put a statement to the court that they thought helped them, that an 11-year-old was asked about the potential of having a relationship or having a baby, and they recoiled. That's not on my radar. No, because you're 11. And the Tavistock, for some reason, thought that would helpful. But anyway, so we had Bell and Tavistock, and that was good news. A slight blip in 2023 when the president of the family division authorised the removal of a teenage girl from the jurisdiction to have her breasts cut off on the basis that she was settled in her male identity. And he dismissed any consideration about welfare. And that's interesting because that was actually the local authority concerned about that, but they were squashed. Even the fact that this child was sent out of the jurisdiction was not a red flag as to a welfare issue. It would not have been lawful for any doctor in the UK to have given a double mastectomy to a perfectly healthy 15-year-old girl. So that was a bit of a concern. But ironically, we then come to the second re-J in our list in 2024. And this is another decision of the president of the family division, who appears to have had a bit of a bucket of cold water thrown over him about the reality of this sort of treatment for children. Re-J's got quite a lot of press recently because Helen Webberley, in her various jaunts around podcasts, has claimed not to have heard of this case, which is really significant because it was Re-J involved gender GP nearly killing a 15-year-old girl by giving her a huge dose of testosterone, one which would have been normal for an adult male. She, of course, was a female child. And apparently, that happened after only 30 minutes of a counselling session online with someone in Gender GP. So the president was very clear. If any case came before the family courts involving Gender GP, that was a massive red flag. This was not a safe organisation. So we can see the cracks really showing now. I then acted for a mother in another case involving a teenage girl who wanted to be a boy. And we didn't succeed at first instance in getting the court to agree that this was a special category of case, which meant that the court could carry on intervening after the child was 16. Because generally, when you get to 16, by action of the Family Law Reform Act, you're deemed to be able to give consent as an adult would to medical treatment. But that case went to the Court of Appeal, and the Court of Appeal agreed that there was such a shifting regulatory environment around the provision of cross-sex hormones that the court could and should take an interest up to the age of 18. Now that's really, really significant because the court had hitherto just refused and said, well, the child knows what they're doing. And this is, I think, quite a good way to segue into what Charles is going to say about CAFCASS. Because the really nasty thing about this case was it later transpired that the child and the child's father had been lying to the guardian and the court. And this child had actually been taking testosterone throughout the whole proceedings. Now, the only place they could have gone was Gender GP. And the father had actually agreed in earlier hearings that he would not go to Gender GP, so concerned was the guardian. I did feel, in my involvement in that case, that the guardian was naive. And I think the fact that the child and the father were deceptive really proves that. And it will be a very strong memory for me for many years to come when I questioned the guardian on whether he really had drilled down to understand this child's ability to understand the nature of the treatment. And yes, he had lots and lots of conversations. But when I asked about what conversations have been had about fertility, there was an almost identical look of almost disgust on the faces of both the guardian and the judge. Because, of course, that's icky. You can't talk to children about fertility. Ew. But it's why everyone who's in favour of this intervention is able to remain in favour of it, because they've also got a really dangerous and worrying reality about the impact on the child for the whole of their lives. At the age of 14, 15, even 16, issues of having a baby may not be on their radar. What about when they're 30, 35? Issues of adult sexual function, again, really uncomfortable to try and talk to, say, a 14-year-old about their ability to orgasm. That's what they're potentially risking. So when the courts step back and are cautious of intervening too much in regulating either the social work or the medical profession, that's why it's so important for the social workers to step up. And I'm really, really worried that that still isn't happening. I'll just give a brief example from quite a recent case I did involving a very small child. I was acting for the mother, and she was criticised for not being able to enthusiastically endorse the possibility that her child might later on adopt another gender identity. And that shows to me very clearly the capture that still pertains in social work. As I said, I talked very briefly about For Women Scotland, and this is the place to drop it in. Obviously, that wasn't a case about children's welfare and social workers, but it did confirm very clearly that sex remains the protected characteristic, not gender identity. So hopefully that will give social workers some of their power back. Because what we saw with regard to Rachel Mead, the social worker who was very seriously penalised for a couple of posts on her private Facebook group, Social Work England got that so wrong. Part of her settlement, I understand it, was Social Work England were going to review their practices and procedure and come out with new guidelines. And again, I'm sure Charles or Maggie, you'll tell me if you know, I'm not aware that anything has been done. And that was what, back in 2023? So I hope that's been a quick canter through where we are now with the family courts. So things are better than they were, but the family court imposes quite considerable limitations on its abilities to intervene. So it's absolutely vital for vulnerable children who are being pushed on a path of irreversible intervention and no secure evidence base, that there are social workers willing to step up to really interrogate and understand what that child is going through and what it means for the child. So I'm concerned for the reasons that I've just outlined that this isn't happening yet. So I'm going to be really interested to hear what Charles has to say about the degree of capture that he perceives is still operating and whether or not we've got a way out of this. I do think there are green shoots with the family courts, but there's always going to be limitations, and we're going to need social workers to step up. Oh, and sorry, I
Absolutely.
should just say, if you're interested in any of those cases, you want to read them, I've got links to all the cases in a Substack post I wrote about the Gen Spec conference in 2024. So if you go on my Substack, you'll be able to find that and get the links to the cases. Sorry, Charles, over to you.
No, I was just going to refer back to the first re-J you talked about, Sarah. And I think I'm right in saying that the judge in that judgment made a number of comments about all the professionals involved and how they'd abandoned common sense.
Yep.
And I think that's what's happened slowly but surely within the whole of the social work profession. Not only sort of losing sight of common sense when it comes to child development and these ideas around gender identity, but also sort of abandoning the first principles of social work practice, which is to ask the right sort of questions. And those court cases you described, I mean, it's important that the public understands, I think, the role of CAFCASS, which it's there to it exists to represent the welfare interests of children subject of family court proceedings, and it's supposed to hold local authority children's social workers to account and to independently sort of scrutinize their care plans of for the most vulnerable children in our country. And so it's difficult for me to speak about individual local authorities' policies and practices, but those I have come across as a guardian, they are almost invariably, pro-affirmation, very little sort of evidence-based thought around child's needs in this regard, and that's a shift because. When I trained as a social worker, that was the core principle of what, how you approached your role. You were there to ask those questions and to challenge and, think about what's happening behind a presenting issue. So that's what I think has happened. And I think within CAFCASS, something has happened. There's been a significant cultural shift, and I'd liken it in some ways to what we're now finding out about what happened within the BBC, another large public sector organisation, which seems to have been sort of lost sight of its core purpose, forgotten what it's there for, really. And I think I just kind of wanted to outline some of the things I've sort of experienced within CAFCASS. I think one of the key factors in this shift has been the sort of the outsourcing of thinking amongst the leadership team or leadership within these organisations to a sort of very small group of activists. And I think within CAFCASS, the Pride Network is a very small group, but with immense power within the organisation. I think it consists of sort of one trans-identifying woman and a sort of handful of people who describe themselves as Q plus, whatever that might mean. And it's a group at which most of the gay and lesbian colleagues I talk to would run a mile from. They don't want anything to do with it. But it's meant sort of within the organisation where things have happened, like we've had to have compulsorily have the trans pride flag on our desktops, during Pride Month. I think I consider that sort of fairly unprofessional, because I think as a government funded organisation, we should be politically neutral. We shouldn't be. We should be objective and neutral about these issues. And it's something which would be visible to service users on my desktop when I'm visiting them in their homes or when I'm sitting in the courtroom, whatever. And it's something I'm very uncomfortable about. But one year that this flag, contained a number of smaller flags within the whole framework of the trans pride flag, and it transpired that one of these tiny little flags was actually the flag of the BDSM leather fetish community. So that's what we were promoting as a professional organization, hoping to be taken seriously in the family court. There's been other issues, the sort of endless posts about trans issues across the organization to almost the exclusion of any other group. The Pride Network telling us about their most inspirational celebrities. I'm not quite sure what that has to do with the sort of serious business of the family court. That remains unclear to me. Never really explained. In 2022, CAFCASS posted on Twitter a book list for children, which included a book by Tori Peters, which contains sort of passages of basically pornographic writing depicting sexual violence towards women, degradation of women. I mean, it was hastily withdrawn, but it's sort of quite telling how, it was an indication of how the leadership within the organization are not doing their due diligence. They're just sort of handing over this issue to people, to activists, really. There's also the sort of yearly spectacle of the holding a minute's silence for Trans Day of Remembrance, the relentless encouragement to declare your pronouns, etc., etc. So far so predictable and almost comical in some senses, but it isn't comical because it's such a serious job that we do, or I did, and a serious aspect of safeguarding children within the family courts. So I thought I'd talk a bit about the actual practice guidance which we have, which it's the rule book essentially that family court social workers are supposed to adhere to. And it's written entirely within sort of affirmative language, refers to the trans child. It not only directs practitioners to always affirm a child's trans identity, but suggests that family court social workers should actually introduce the topic into the conversation when they're working with vulnerable children. I can read from the guidance. Here's a question of how practitioners are encouraged to start these conversations with children. Can you tell me about your gender identity? Your parents have told me that you are a girl or a boy. Is that what you think too? Some young people talk to us about where they're at with their gender identity when we talk to them. Other young people don't know yet or haven't started to think about it, and that's fine too. Now, by anyone's reckoning, I don't think that's a neutral exploratory question at all. And within the guidance, the starting point is that children should always be affirmed in their trans identity, and parents who don't should be considered a safeguarding risk to their child. The guidance actually directs practitioners to consider seeking court orders if parents or carers are not affirming their children. I mean, the first principle of social work practice and child safeguarding are lost entirely in that. There's been no exploration or questioning of why a child might be presenting with gender-related distress, no consideration of the wider family and social context, the psychosocial factors at work in it. No real consideration of how a child presenting with these issues might relate to abuse or neglect or sexual abuse.
Sorry, Charles, can I ask, what is the date of that guidance?
It was reviewed earlier this year, so that is the current guidance. And
Good Lord.
as we've discussed within EBSWA on a number of occasions, I've tried very much to challenge and sort of participate in the reviews of this guidance, but it's ignored or sidelined, and that's as it stands at the moment. And any sort of guidance of this kind should draw on the best available evidence, not ideological perspectives. We were talking earlier about the CAFCASS review. Within the guidance itself, the CAFCASS review is only mentioned once, and in the context of how the review has made it more difficult to access puberty blockers, and how discredited these now discredited pathways towards medical transition. It does mention Bell v. Tavistock, but not as a consideration of the experience of detransitioners.
But Charles, so it's revised this year. So is there any reference to the fact that puberty blockers are now unlawful outside of a clinical trial? Is there any mention of that?
No, and it still contains a link to some doctor at a Boston hospital who's been a big advocate for puberty blockers. So you can watch the video, and he's talking about how they're fully reversible, etc., etc. So it's just ignoring the current evidence.
That's really, really shocking. I'm sorry, I hadn't realised that this had been reviewed so recently. So you
Yes.
would not know from reading that guidance that there had been the Bell and Tavistock case, the CAFCASS review, the need for further guidance from Social Work England, from Rachel Mead's case, and the fact that medical transition for the under 16s is now unlawful. You wouldn't know it from that document.
You wouldn't. I mean, as I said,
Bloody
it
hell.
does mention Bell v Tavistock. It does mention the CAS review, but in a context which don't convey the true impact of those, the CAS review
I'm
and Bell v Tavistock.
So
I'm
just
genuinely shocked, and I'm wondering whether there needs to be some actual concrete legal challenge to this, because that, going back to the points I made about children in care being uniquely vulnerable, that is unlawful guidance, surely.
Well,
Well, I have to say, I mean, before Scotland gets let off the hook here, that although it has got a different, slightly different, well, a different role, the Care Inspectorate in Scotland has issued guidance almost just exactly like that, which is, we think, unlawful. And and exactly the same, when they were challenged, they mentioned the CAS review, it completely misused it, misquoted it, didn't misquote it, but took completely irrelevant bits of what Cass had said rather than the main
right.
messages. So yeah, we have exactly the same problem here. I think we can go on. We'll let Charles finish, Sarah, and then we can maybe go on to talk about, best ways of challenging and what the experience has been of that. So,
Yeah.
you want to
Well,
stop?
just think about how outmoded the guidance actually is. I mean, it's still signposting practitioners and exclusively to trans activist organizations like, Mermaids, Gendered Intelligence. It doesn't really give any consideration regarding the backgrounds and experiences of the cohort of children who went through the Tavistock, and the proportion of autistic children, care experienced children, and the very significant shift in numbers of girls presenting with gender distress. So, as I say, those of us who have tried to challenge the guidance and the general culture within, CAFCASS, like I say, I've offered to contribute to a review of it from evidence-based perspectives. We've just been ignored and sidelined, and the guidance still stands as it is. So, in spite of the CAS review and in spite of the Supreme Court ruling, we continue to see these very troubling outcomes, for a lot of these troubled young people that in the family court you've been talking about, Sarah.
Yeah, I think local authorities, I think social workers in local authorities have reported similar experiences. But I think what's significant about CAFCASS and the Care Inspectorate and any official bodies is that they actually are supposed to be setting a standard and
Exactly.
regulating care and services that they provide. So it's really what hope would any social worker have, or any worker in the care service or any foster carer, in not following the Care Inspectorate guidance or the CAFCASS guidance. So I think that's why it's important. And we have actually, EBSWA has actually had quite a correspondence with CAFCASS over the years, and with the Care Inspectorate, but not to any great effect. So I don't know where you want to take the discussion.
I think Sarah's point is very valid in that it's the social work profession itself which has to gear itself up and use the evidence-based knowledge and see past the ideological considerations which we're very much prey to within social work, I think.
Yes,
I mean,
Sarah.
I am shocked because what I thought Charles was going to say is that this was old-fashioned guidance which nobody had got round to looking at again, because obviously they didn't want to. There was no incentive. It chimed with what they believed. But what he's saying loud and clear is that somebody's reviewed this in light of everything that we've just been discussing, and they've deemed this lawful and prudent guidance for social workers. And I'm genuinely shocked. And I'm
Yes.
going to contact my solicitors now and ask if this is something they'd be interested in looking at, because we cannot allow this to go unchallenged. That to me suggests that the ideological corruption goes so deep that safeguarding children is obviously thrown out of the window, but also the decisions of the court, an independent review commissioned by the government, and the actual now illegality of medical transition for the under 16s.
Mhm.
This is genuinely shocking.
Mm.
Right, well, thank
Yeah,
you.
well,
You've given me an impetus.
I did have an email exchange with the principal social worker within CAFCASS, the person whose job it is to oversee practice and policy. And I did that on several occasions. And I certainly, the last point I did it was following the Supreme Court ruling for Women Scotland ruling. And the response was, our guidance is well thought out, well considered, and that's what it is. So I don't know what else can be done apart from potentially legal challenge.
Well, I know there are critics of lawfare, but I think when you reach this brick wall and you've tried reason and dialogue and discussion and there's just refusal, I honestly don't see what the alternative is. I don't see how we change the culture without a big stick. But of course, that's also naive because I saw what happened in Rachel Mead's case. And as we said, we're still waiting for guidance from Social Work England, revised guidance. But I just can't think what else we can do. I mean, this is horrifying.
Mm.
I thought in my little canter through the family cases that we were moving away from Read TP and the 4-year-old and the 7-year-old who had no adult to speak for them. The one adult who tried was quashed because that was the CAFCASS guardian who'd be operating according to this guidance. So it was very brave of her to speak
Right.
up at
Yeah.
all. And no doubt she was told in very clear terms she had to shut up about it.
Well,
I'm at,
I've had the same experience when similar situations have occurred for me, when I was practicing as a guardian.
I'm just absolutely flabbergasted. I can't think of another issue which has been able to so thoroughly and effectively utterly hijack entire organizations, particularly ones which are supposed to be directed to safeguarding children.
Well, this is the most frightening thing about it is that it did happen in social work where and one of the big difficulties that EBSWA has had in talking about it and publicizing it is that social workers are afraid to lose their jobs because more than Rachel Mead were actually investigated, and we don't know how many have been warned, how many were disciplined, how many were warned at work, as Rachel was. But despite Rachel winning her case and Lizzie Pitts as well in Cambridgeshire winning her case, nothing changes, and so we still have a situation where we have very few social workers able to actually or feeling able to speak publicly and to even talk with their colleagues at work. There's some research done by Professor Jane Fenton in Dundee, who's now retired, but and I think we're going to do a podcast with her in the new year. And her research was about the silencing of social workers. She asked her students what issues they felt they couldn't discuss openly. And the fact that this is social work and supposedly protecting children, and it was one of the first organizations to fall. I do like, Charles talking about the BBC because in a way it's a similar thing. The BBC is paid. It's there in order to report honestly and truthfully and yet that was one, it's been exposed how we knew how much it had failed, but they've now had to acknowledge it. And you wonder what kind of shock is going to have to be administered to social work and the regulatory bodies to have the same effect, which I think we can see it's having that effect in the BBC, and that journalists are now able to say, no, we're going to talk the truth, we're going to speak the facts.
Yeah.
So yes, it's that the silencing has been very serious. And of course, if you're silent and afraid as a social worker, you can't protect children.
Of course.
Nobody who's
Yeah.
afraid
Yeah.
can protect
Yeah.
children.
No, it's I think you're right, Maggie. It's this, a large part of the issue is the sort of stifling of debate and not allowing other perspectives to be aired, basically. And I think a lot of social workers are I can't believe I'm the only person within my organization that I work for, felt the same way, but yet the voices were not, just not present. It's just, I don't know whether it's a culture of particular organisations, but in social work generally, to be to be seen, obviously we like to think we're progressive, and we mustn't, we mustn't appear prejudiced or bigoted in any way, and that's the sort of response you get if you raise these kinds of issues. That's a transphobic thing to say or whatever. Well, no, I'm just sort of questioning what's happened with this child, and why might they be presenting in this way.
Well, I hope this is the benefit of the kind of thing that we're doing tonight, even if just one person hears it and realizes that you are allowed to discuss these issues in a sensible way. It doesn't make you a raging bigot,
Right.
homophobe, or transphobe. That these are actually things that are perfectly lawful and necessary to discuss. Because I'm thinking about what brought the BBC down. It wasn't that an internal memo. So it was somebody within the organisation who was worried. And that's, I think, what's going to be missing from social work. Because as Charles says, it's captured right at the very top. And those lower down the hierarchy are desperately worried for their jobs. And that's a really dangerous combination, isn't it? But I'm seriously thinking that there's got to be something. I mean, what would be the equivalent in the social work the Director General of the BBC, who's the equivalent, the chief social worker, stepping down? It would it have to be that seismic to see any change?
Well, I think that's probably the case. It would have to be that seismic. It certainly would. Um, the leadership of Social Work England should have gone over the Rachel Mead case. The leadership of the social work leadership of Westminster Council should have gone over that. That there was, but in fact there is what's almost a campaign of disobedience and denial of the law going on, not just in social work, in
Mm,
local authorities. There's almost a sullen and defiance where the CAFCASS's guidance has stayed the same. The Care Inspectorate in Scotland's guidance has stayed the same, and nobody is keeping count. I think one thing recently in the last few days, the outrage over the puberty blockers trial and it being emerging that children in care, no matter what their histories of abuse or um, trauma and what their condition of autism or any other thing, that will not, they will be taking part in the
part
trial
in the child.
with the consent of, their social work. If the consent of the social worker. I think it even said or foster carer or whatever, which of course legally isn't the case. That the parental consent is only children that are looked after.
Yeah, but we see how instrumental the foster carers were in the TP case. They were the ones pushing it. They
Yeah.
were the ones joking, another one for the Tavistock, and the social workers fell in line. So again, it's this kind of folie à deux, isn't it? And
Mm,
foster carers, well, they won't be allowed to be foster carers unless they get in line, and they
mhm.
will be questioned on their views about gender identity. So it's ensuring that nobody at any stage can speak out if they want to keep their job and their position. It's really bloody frightening
Mm. I
because
certainly
that
know,
was
yeah, people refused registration or acceptance as foster carers because they took
mm,
an absolutely, totally sensible approach, which was that they don't think that there's any evidence to support. And this was puberty blockers. They
well,
just said they would not like want to promote taking children, get teenage girls for puberty blockers, and
but
they were
as Charles said,
immediately. They're,
if the guidance says that you take parents to court if it becomes a child protection issue that they won't affirm,
mm,
then of course you can't have foster carers stepping out of line. I
mm,
mean, this is absolutely. I mean, do we know? I've heard rumblings. I've read some reports of cases where parents are saying our child was removed. I've not been involved in any case where they're talking about removal, but there've certainly been things said that made me worried that that's how a case could go. I mean, does anyone keep any statistics about this within social work? About the reasons, because no, CAFCASS does publish statistics, aren't there? I've seen statistics about emotional abuse, physical abuse, but I suppose it would just be subsumed within emotional abuse or even physical abuse if a
I
child
imagine
was
so.
removed because
I
a parent
imagine so.
wouldn't affirm.
I don't
Yeah,
I don't think it drills down into
no, it
what
doesn't.
those presenting issues would be. No.
But
No, it's quite broad
there was a
brush.
report by um, IPP, the in absentia parentis, um, which did do freedom of information requests to local authorities and basically what they found out was that very few local authorities were keeping a track of children whose sex markers or records they had changed, or children who they transitioned in care. And I know EBSWA, we're going to do the same exercise in Scotland, but also to do some sort of follow up in England about the actual facts, because basically by not recording them, we're being denied information. They'll be denied outcome information, because if you don't know how many children you've transitioned or how many children you may have taken into care, what was the emotional abuse? Not recognizing. Having said that, I do hear quite a few examples of parents whose schools have actually referred them to social work up here, and the social work authority has taken a very sensible line, and just said, no, it sounds like you're doing all the right things. You've, got arranged counselling for your child. You're talking to your child.
Yeah.
You're concerned. You're doing the sensible thing. We don't have any concerns. Partly because they just don't want to take any more
Yeah.
children
I mean,
into
that's
care.
what
It's
I mean.
very
There's a
expensive.
foster carer crisis, isn't there? I
Yeah.
can't believe that social workers would be gunning to
No.
take children away on that basis, given that there's nowhere to put them. But
However,
that's in the guidance.
once
Yeah.
in care, they're in an absolute brew of where the care inspector has said proselytize these children, festoon children's homes with LGBTY
Mm, mm.
information, mermaids, make that, and one of the care inspectorate's examples that they gave of good practice was where a young person who was exercising their right to stay on in care, so they were over 18 but still in a children's home, a residential home. The example of good practice was that she'd been supported to go and have her mastectomies, and had been very, the social worker had been wonderful, not the social worker, the residential care worker, and how wonderful the whole place had been about encouraging and supporting her for this awful mutilating surgery, unnecessary surgery. So that is this. It is as bad as that. That that things are. But as I say, I'm not sure how widespread a fanatical support for it is, or whether there's a kind of quietness around it. And I think some of our other
Well,
practitioners in local authorities
yeah,
have kind of said there's a quietness around.
yes, and I'd like to think that perhaps more experienced social workers would be able to cut through this, and navigate that through what their organizational expectations are as well, and do the right thing for children.
I think with maturity and experience, like you managed to avoid trouble despite being actually quite openly um challenging, questioning, and
Not
stating
entirely, Maggie.
exactly clearly you
Yeah.
did stay out of trouble, yeah,
Mm.
and you did it very professionally. And I know that other like Robin Carling, who's got his own Substack, he has managed to make good progress with his local authority by taking exactly that line
Yeah.
of being confident about evidence, coming forward and saying, oh, what about this? And not treating it as a matter of ideology that you must believe or you must not believe, or what side are you on? It's just actually of saying the evidence, these are the things we have to worry about, and always going back to social work, the practice issues.
Yeah. First principles. Yeah.
Yes, some first principles. So, Sarah, I'm I suppose interested in your idea of a legal challenge, because it's not something that we've thought possible really, just because who would pay for it? Because I don't think that there's a groundswell of social workers ready to go to the barricades on this, and I don't know if there's enough support or awareness for a general lawfare appeal.
Well, it's got to be worth a try, hasn't it? And we need to, for a judicial review, we need to find someone with standing. So I guess that would possibly ideally be a social worker. So that I appreciate is difficult. but somebody who's retired or was near to retirement, and then test the waters. I mean, there may be funding available. It just, we can't just let it slide. I'm really, really shocked. I really thought we would just have this inertia. This is guidance from a couple of years ago. But no, it's been reviewed recently. And I'm now remembering that I did write to the president of the family division a couple of years ago on the whatever iteration of the guidance there was then, saying this is unlawful. And I wasn't even given the courtesy of a response. Something very, very wrong is happening here. And I know that lawfare is imperfect and it's expensive and it's emotionally draining. But what else can we do? Although we're seeing the failure of lawfare with Rachel Mead. I mean, the only comfort is if another social worker is put in her position or the position of Lizzie Pitts, then they can be very confident that they will be protected. But it doesn't seem as though there's anything to stop this happening again and again and again. But my worry, I mean, that's what's actually enabled me to be so robust in this debate, because it is about children who need protection and are not only not being protected, they are being hustled down a pathway of absolute devastation. And I just don't see how anybody with any understanding of these issues could sit back. So I certainly want to think about that and raise it with my solicitors, see if they could help. But I think this guidance is just wholly wrong. It's unlawful, and it's going to risk the actual physical safety of children.
Oh,
It,
I'm quite sure that physical safety of children has been well risked and children have come to harm. But I mean, on the other hand, it's not the situation in schools and where teachers are is no different. The EIS, well, it's the EIS up here, but and the GTC, all the teaching organisations are
but
fully
if there isn't the
committed.
pipeline, Maggie, that's what worries me. Teachers don't have the power to take your children away from you. Social workers can go to the courts and exercise that power. So I think stopping the pipeline, if there's no ready referral route for teachers, then hopefully that might cut down on some of the excessive zeal in the teaching profession. It's got to be worth a shot, though. I mean, I fear social workers more than I do teachers, simply because of the broader range of powers and threats that a social worker gone rogue can exert. A social worker who has forgotten that their duty is to form relationships with people who are oppressed and help them is really bloody dangerous, because there's a panoply of state power that
Well,
is
yes,
then behind them.
they have the power of the state at their
Yeah,
disposal. Yeah.
yeah,
Yeah,
yeah.
I mean, I personally, in my line of work as an independent social worker, working with parents, I think that's been a general problem of social workers' power being misused, abused, where in terms of intervening in family life without due care and attention and with ideological or other beliefs. So I think that there is a broader problem there, and it's not just this one aberration. There are issues around the
But,
relationship.
but this but this is
Whereas
the
schools,
absolute worst, isn't it? This is the worst of ideological corruption, because there is now evidence upon evidence upon evidence that it's simply based on nothing. Whereas I can kind of understand some of the other social justice practices, but not this one, because it actually involves hurting children very directly. And all the evidence is, all the way the government's been reacting shows that. So it's far more pernicious and dangerous, say, than Black Lives Matter or let's wave a rainbow flag. There's something really, really rotten here, and I'm genuinely shocked.
yes,
I
but
thought
there
I'd
is.
just be chancing along saying, "Oh well, maybe they'll revise the guidance, Charles. Don't you worry. I'm
Well,
sure they'll get to it." But they have revised the guidance, and this
yeah,
is what they've come up
yeah.
with.
I mean, I think you're right, and it's in the case of the BBC, it's just we get subjected to endless awful programs about drag queens, but this is more serious, isn't it? This is actually impacting on the safety and welfare of children.
Yes, and when
Using
you
the
imagine
coercive
children,
powers.
sorry, Sarah.
Sorry, Meg, I was saying, yes, using the coercive powers of the
Yes.
state to ram it through. That's, I think, what makes it different from any other sort of annoying social justice practice, which is often no more than a bit of a performance, a bit of a lanyard.
Yes, and particularly when you look at the puberty blockers, we touched on earlier, it's terrifying to think of children being encouraged to believe that they're trans children in care and special, and then the consent being given on their behalf to embarking on this trial. It really is, because for parents that's the worst nightmare, is to have lost your child and not be able to protect them in care. You know, they're in care, they don't get a chance to talk to them properly. They don't often get told about decisions that are being made. They don't get involved in, talked about their child's best interests or what's happening. And then to know that something like this could be happening to their child is agony. I mean, and it is now one of the things that parents have begun to raise when they're when you talk to them about the future of their child in care, when they're being consulted about adoption as an option. I mean, I was really surprised, and it was 7 or 8 years ago, a young woman said to me, um, as long as they don't place him with a trans couple. And I was quite surprised, thinking, oh, really that wouldn't be likely to happen. And I then found out it was actually going to be placed. I couldn't believe it, but that was the proposal, that he was, and which I found really, that was 8 years ago or more. So I don't know how far it's gone along those lines, how many people,
And say, how
that's
did that go? Yeah.
the other bit of information we lack, how many people have been approved as carers who are adherents and supporters and trans identified, and how many children are being asked to call men mummy or mum or their foster mum. We don't know this, but I mean, I do know that in areas of Scotland that I was astonished about, that there's still, like rural areas that you thought would have been absolutely remote from this. It's not the case. It is actually a very alive problem and ideology there. So have we any last thoughts? Are we about to embark on lawfare, Sarah?
Oh,
We'll
no,
await
thanks
your
for really depressing me. I was thinking
sorry.
I'll give my little speech, and it's sort of green shoots of positive signs that the family courts are restoring sanity. I mean, I've always thought the higher courts were not captured, and I think I've been right about that. But the family courts are still showing a great reluctance to really step in and say, look, this is mad. And that's what I found very frustrating in the O&P case I referred to, because the family courts do have this ancient jurisdiction, the parens patriae jurisdiction, which means protection of the vulnerable. And they're not willing to use it because they say, oh, we don't want to step on government's toes. We don't want to interfere in making law. But I was thinking things were going to perhaps be okay. But if CAFCASS have instead embraced what to me sounds like completely unlawful guidance, as you say, Maggie, it's part of this general petulance and refusal to obey the law, which is so shocking. And I suppose it's the overhang of Stonewall saying go beyond the law. But for women,
Mhm.
Scotland couldn't have been clearer, could it?
No,
Sex is the protected characteristic, and yet every, everyone's just refusing, got their fingers in their ears.
but
So
for
thank you. I'm
children,
very
of
depressed
course,
now.
I think that's one thing that we really should be pressing home, is that sex is a protected characteristic in children as well as in adults. That
Yeah.
Probably, yeah. Yeah.
so you don't say to a child, "Oh, your parents have told us you're a girl," but
Mm.
who knows? Like that's denying them the protected characteristic of sex in a way, because you're denying that it's any reality in the
Yeah, of
world. Whereas, yeah, it
course.
is.
Yeah.
So, so I'm not feeling as pessimistic though as you, Sarah, on that, because I think people and the courts and public opinion and everything else is well ahead of the CAFCASS guidance. Social Work England's up for review, and certainly our members and others will be pointing to their many failings in this regard. And I think this guidance will melt, like, as we say in Scotland, it will melt like snow off a dike once any attention is paid to it, and they'll be
Oh, that's
denying it. And
Maggie, that's a really good point about the review of Social Work England.
yeah,
They're consulting, aren't they? And I think it closes on the 26th of November. So can people really please, if they feel able, make some comments to that review to Social Work England?
Yes, I think I don't know if this podcast will be out by then, and it probably wouldn't have that much immediate impact. So we should make sure to do it online and try and
Yeah.
encourage people to
Done.
do
Yeah.
it.
But I think
So-
if people are fed up of lawfare, and I can understand it, there are other ways, and this is one. Obviously, write to your MP, make your voices heard. But when people actually consult, engage, we've got to get through to them somehow.
And I think cases, I mean, it might very well be that we will have a case soon, or there might be any of deep transitioners of young people who've been through this process and experienced what they've experienced and be like Kira Bell, unable to actually change their future and change what's happened to them. So right, so I think that's probably we've had a really good discussion. Sarah's been shocked, and we're possibly going to embark on some lawfare. But thank you very much, Sarah, for your very thoughtful comments and your shock,
Thank you.
and which is good to hear. And thanks very much, Charles, for sharing your experiences in CAFCASS. And we'll look forward to the next stages in this. So thanks very much,
All right.
and
Thanks both.
bye.
Take care. Bye.
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 Bye-bye.